members may be coming on in. There's a couple others. So thank you. This is, as I mentioned from the floor, today's meeting is an informal meeting, not doing any bills. We're going to be hearing from the task force. Before I mention that, many of you know that we have gone to a subcommittee system within the Judiciary A, which I think is going to be very beneficial. And there's a similar system over in the House. So Angela and I have talked about that. So as you recall, last year we did Senate Bill 2621, which had set up a task force to study certain issues, and that task force occurred. We have with us today Judge Odom, who was ceremoniously named chairman of that task force, and Chairwoman Cockerham and I were on that task force. I will tell you, just out of kind of some personal observations, I thought it was very well done based on the feedback that we got. The judges in particular and legal practitioners were very glad to see that we were doing it, and there were some tough issues, but I personally want to say thank you to Judge Odom as well as to all the members of the task force, because they took time to come up here to Jackson or down here to Jackson, depending, go through these issues and work with the Senate staff, the House staff, with Chairwoman Cockerham and myself. And I think that we got to some issues that were very important within the legal system. And so I appreciate what they did. And to that end, and you'll hear about it, looks like we will be continuing that task force to address other issues, which can only benefit us, certainly with not only the legal practitioners or the judges, but also the people. So with that, I'm going to turn it over to Judge Odom and ask him. Judge Odom, everybody has been given a copy of the report that was released. And if you would just please tell us about it and what your thoughts are.
Thank you, Chairman. Troy Odom, Rankin County Chancery Judge. So glad to see a friendly face in here from the good confines of Rankin County. Chair of the Legislative Domestic Relations Task Force. I'm glad that y'all all have a copy of the task force in front of you. Y'all can see the individuals who were appointed or otherwise named to be on the task force. We had appellate judges, sitting Chancery Court judges, law professors, some of the most experienced family law practitioners in the state of Mississippi. It was an honor to be appointed by Justice Randolph. It was an honor to serve as the chairperson, and Mr. Wiggins, and I would tell Representative Chairwoman Cockerham the same thing. It was an absolute joy to work with y'all and your staff here at the state legislature. Everybody was incredibly competent, friendly, intelligent, and made the process so much easier for those of us that aren't normally here at the State House. So thank y'all. And thank y'all also for the audience. It's very rare that a judge gets an audience with those that are directly involved in making the laws, and that's not an opportunity I would ever want to pass up. So by the time that the appointments had been made following the enactment of Senate Bill 2621, which was July 1, by the time the appointments were made, we had our first meeting in August of 2021, and with a report that had to be finalized by December 1 of 2021. That left us approximately 3 months to get to work. And as you can imagine, with appellate and trial level judges with busy dockets and practitioners with heavy caseloads, we tried to get in as much substantive meetings as we possibly could in those 3 months. I'm proud of the work that we were able to accomplish. We did make a few recommendations. It's not difficult reading there in the report before you. Most of that is minutes and appendixes, but I would like to highlight those recommendations that we made a little bit more in depth. The first order of business was to review current trends in no fault. I say no fault in quotations because it's not necessarily a true no fault. Divorce statutes that the state of Mississippi has, and to make recommendations based upon our review. I feel comfortable in saying that this one topic was foremost on the minds of every single person that sat on that committee. I spoke individually with the majority of the members on the committee privately, and I had quite a few say that's the reason they requested to serve on the committee. So I made it a point for it to be first and foremost in any review made by the committee. It's an issue that those of us that are in the field, we immerse ourselves in every day that we're on the job. And I can feel comfortable saying that we strongly feel that something should be done, and I cannot emphasize that enough. Something should be done. The first recommendation was to provide 2 additional fault grounds for divorce, one based on an irretrievably broken standard, the second based on a complete incompatibility standard, both of which are used by our neighbors here in the South. Proposed language for those bills is included in the recommendation, and I don't want to belabor this issue because I know, particularly for those members of Jud A, y'all are inundated with this issue on a yearly basis. As it currently stands, unless both husband and wife agree to a divorce, a person cannot separate themselves from a destructive marriage unless they can prove by clear and convincing evidence one of Mississippi's 12 fault grounds. The one exception to that is, of course, habitual, cruel, and inhuman treatment, which only requires a preponderance of the evidence standard. However, even with that lower standard, habitual, cruel, and inhuman treatment can be one of the most difficult fault grounds to prove. Clear and convincing itself means evidence so clear, direct, and weighty and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts of the case. That's a pretty high standard for us judges if we have to come to something without hesitancy. So clear and convincing is an incredibly high standard to meet. The case law from the Supreme and Court of Appeals is replete with cases either confirming a denial of divorce or reversing a grant of divorce because the necessary facts were not proven by clear and convincing evidence. As for habitual, cruel, and inhuman treatment and its preponderance of the evidence standard, it's only upon a showing, and this is even after the recent or the 2017 legislative amendments allowing for spousal abuse to be proven. But even after that, it still requires conduct that either endangers life, limb, or health, or creates a reasonable apprehension of such danger, rendering the relationship unsafe for a party seeking relief, or is so unnatural and infamous as to make the marriage revolting to the non-offending spouse and renders it impossible for the spouse to discharge the duties of marriage. These are This is language that we have to deal with as chancery judges on a daily basis when we're making findings of facts and conclusions of law on whether or not to allow, or if we can allow, for a destructive marriage to be ended by divorce.
Judge Odom, sorry, I'm going to interrupt you right there because I think it's a good point. You said this was the number one thing. Can you tell the committee, because I know it was discussed, what y'all see, why this was number one, why, what you see in the courtroom, why is it such an issue that this recommendation come forward based on what the judges see and the attorneys and so forth?
I apologize for lecturing. I've never done this before, so I didn't know exactly how to prepare for this, but I'm glad you're cutting right to the chase, and I'll stop the lecture. Okay, so there are a number of reasons that we bullet pointed in the recommendations, and I wish I could take credit for these bullet points. The truth of the matter is the majority of them came from Professor Bell at the University of Mississippi School of Law, and then the committee added to them and edited those. But on page 2 of the report, you can see at the bottom those bullet points. We don't want to preserve marriages that are dead, right? We don't want there just to be a marriage in name only, because the vast majority of the time what you're seeing is lengthy separations from two individuals that are still married but cannot, that are completely incompatible, right? It is not uncommon in Rankin County, and I'm going to go ahead and say that it's not uncommon in many of the other Chancery Court districts for trials on fault grounds alone to take many days. What we do is we try to bifurcate fault from custody, support, alimony, property division to make that determination of whether we can even divorce these individuals under the state of the law that it is today. So we often have multi-day trials that we could be handling something far more important than trying to make a determination if an already dead marriage meets the requirements under the law for a divorce. It therefore increases the cost of obtaining a divorce, which is primarily a concern with moderate or lower income individuals in the state of Mississippi, those that are usually needing to get relief the most.
I'm particularly interested, or see the one allows a spouse to blackmail the other.
I was going to hit that last.
Oh, okay.
Because that's by far the most important. But Mr. Wiggins, you've got things to do. I'm going to cut right to the chase. You're absolutely right. This is how it happens most of the time, if not all of the time. When a spouse objects to and fights a divorce, I've never seen a situation where it's because the spouse wants to save the marriage. The spouses know the marriage is over. Rather, it is to be used as a bargaining chip, whether it's custody or visitation or not wanting to pay alimony or trying to lower that child support payment or trying to keep all of that 401k or retirement account that they acquired during the marriage. It's used as a bargaining chip. I have yet to see a situation where a spouse said, I want to keep the marriage because I love my spouse, and it's important that we keep it going. I've never heard a litigant actually say that. Negotiations, it's very clear that it is a negotiating tool used by the parties in order to negotiate the lesser important aspects of it. And occasionally we have to deny the divorce because it doesn't meet the standard as the state is provided under the law today. And that creates havoc. Because when we deny the divorce, the two spouses don't just automatically look at each other and say, well, I love you again, let's give it another shot. That's when the lengthy separations take place. That's when the children are now separated from their other natural parent without a custody decree in place. That's when it prevents a custodial spouse the opportunity to bring another parent, another spouse into that relationship, so you can have two spouse households rather than just one spouse households, because you can't get married if you're still married. So that is, yes, that's the number one reason why, in my opinion, and I think it was also the opinion of the other members of the committee, why a lower standard was recommended, so that we can cut to the chase and get to the real meat of the matter, which is the custody, the visitation, the support, and the property division. Thank you, Chairman Wiggins. I appreciate the question.
Probably the best is, because I know there's 4, so if we have questions on each recommendation, that'd probably be the best way to handle it. So, yeah, Senator Barrett.
You'll get rid of me quicker that way. Go ahead.
Thank you, Mr. Chairman. Judge Odom, thank you for doing this. Would this, I guess, amendment or addition to our law, would this make the affidavit of non-collusion or a no collusion affidavit obsolete?
No, it would still be a fault ground, and under the state of the law, you would still have to have that affidavit of non-collusion. I haven't thought about that issue of whether it's still, no, you're still going to have to prove that the marriage is irretrievably broken or there is complete incompatibility. There was a split on the committee as to whether to recommend a true no fault. Anybody can walk into a courthouse and get a divorce regardless of what the facts are, which that alternative is provided for you in that report, or to make it, I've been married 20 years, happily married. I would be shocked if my wife walked into the courthouse and divorced me tomorrow under a new no-fault divorce statute. So the recommendation was to still provide some showing satisfactory to a chancery judge that this marriage is in fact irretrievably broken. There's complete incompatibility, and it sounds to me that that would make the affidavit of non-collusion even the more important.
Yeah.
Senator,
Thank you.
just the task force found, because they did research, contrary even to my own personal belief, to common belief, was that other states had pure no fault. What actually was found by the task force is that the majority of your states have this, not a true no fault. It's a version of a fault ground. And correct me if I'm wrong, Judge, but that's what the committee came forward with, is it's not no fault, it's another ground that is that one person can do based on these standards. And as he said, I think it certainly is in Alabama. I think it's in other states. Is that accurate, Judge?
Louisiana, Alabama, Tennessee, they all have, each of our neighboring states have it. And the 2 states, Mississippi and South Dakota, are the only 2 that have as restrictive of a marriage or divorce system as the state of Mississippi does.
So back to your question, it's not a no fault, thus I guess maybe the affidavit, because you are coming, but it's a fault ground of irretrievably broken, or what the other one is. Somebody else have a question on that?
That was the main issue. If there are no further questions on that issue, oh, I'm sorry.
Senator Turner Ford.
Thank you, Mr. Chairman. Judge Odom, how does this, with the current framework, there is a 60-day waiting period for an irreconcilable differences divorce. Would that still apply under these recommendations?
No, it would not. You would still have to serve the opposing side with Rule 4 summons. They would still have 30 days in which to answer the complaint, and you're still going to have to set that matter then for hearing after that person is served. So in reality, due to the state of court's dockets, it's going to be far more than 60 days if you proceed under this type of fault ground.
So what is the standard for the complete incompatibility? And I just haven't had a chance to read it.
Oh, no. We did add the language in here, and I'll touch on that. A chancery court may divorce persons upon application of either party when the court is satisfied from all the evidence that exists such a complete incompatibility of temperament that the parties can no longer live together. Goes hand in glove with the irretrievably broken standard as well. This is just suggested language from looking at other states' statutes. Of course, we leave the drafting of it to those that know what they're doing.
One last question. How does this proposal get past our current framework where you still, the litigants are still required to go to court, prove their side, bring forward witnesses? How does this recommendation bypass that process?
It doesn't. It's just a different, lower standard in which to obtain a divorce. You're still going to have to put on proof and satisfy the Chancery Court of a marriage that is irretrievably broken or a complete incompatibility between the two spouses. You're still going to have to prove that.
And did the task force consider how long the marriage would have to be in existence if they were going to plead for this
No,
relief?
honestly, that was not a consideration of the task force, and I don't know that I would think that it would be necessary to be one.
I was just wondering, what stops someone from getting married after 30 days and they're saying it's just an incomplete incompatibility?
Nothing stops them from doing that now and claiming any of the other fault grounds for divorce. We get quite a few, unfortunately, divorces that lasted only a mere matter of months between some individuals that didn't realize how violent, for example, their spouse was when they married them, or the habitual alcoholism or drug use that was evident, or even the incurable insanity that was present that they didn't know about when they got married. I wish people put as much thought into getting married as they sometimes do getting divorced, but it's not uncommon for the other grounds as well.
And one final question. Would the current vehicle of the joint complaint, the 60 days, that would remain in place? Or is the task force recommending that be deleted
Senator Ford,
totally?
I think I can answer that.
Okay.
I checked with counsel. I think this is more of a, understand the recommendations do not touch irreconcilable differences ground. And I think in talking with Senate counsel, there's no reason that we see based on these recommendations why that would change. And now, practically, like once things, if it becomes law and it flushes out, how that plays out, that may be down the road. But as far as the task force recommendation, and nobody suggested that the ID divorce process be changed. If nothing else, correct me if I'm wrong, Judge Odom, but it would just be an additional ground that gets added to the framework.
Thank you.
It would be, as I tell individuals, parties in my in the courtroom I use all the time, it's far better if they can come up with a resolution to their own relationships than the court, who doesn't have much knowledge of their relationship other than what I hear and is admitted into evidence. So I'm glad that the framework for ID, as unfortunate as it is, will remain in place.
Any other questions on that? Okay, you may continue.
Yeah, I would like to touch on, and when I start lecturing again, Chairman, just let me know. I want to touch on the fact of child support. There were the first two charges in Senate Bill 2621 was for the task force to look into Mississippi's method of computing child support. And you're going to see that there's not a recommendation in there concerning whether to move away from the percentage of income model and go instead with a income shares or Melson formula model. And I wanted to explain that briefly so that you know that we weren't just sleeping on the job. It's a monumental task, and not a single person in that committee was adequately knowledgeable about the child support calculations of other states to be able to realistically and substantially digest the income shares model, which is used by the vast majority of states. I want to say 41 states use the income shares model. Mississippi is one of 6 that still uses a percentage of income model, which is great for chancery judges because it's easy to compute. You take what the adjusted gross income is of the non-custodial parent, you apply a statutory percentage, 14% for one child, 20% for 2, and so on, and you come up with what that person will be paying in child support. The income shares approach has been other states have been rotating or gravitating, toward the income shares approach because it takes into account the non-custodial parent's income as well into the calculation. I could see that the committee was going to get bogged down and perhaps take up the entirety of our time discussing those issues. So what we decided to do was table that issue. We explain it in the report and begged to have the task force reconstituted so that we can bring individuals in that could better inform us of the advantages of the income shares approach and how it would affect Mississippians, because we're different from people in Arkansas, and our economics are different from people in Louisiana. So we wanted to make sure that we adequately studied that before giving a recommendation. What we were able to give a recommendation on concerning child support was a bill, if I'm not mistaken, that was it was brought up in the 2020 or maybe 2021 legislative session concerning continuing child support for adult disabled children beyond emancipation. And that was our number 2 recommendation, if I'm not mistaken.
Yes, and Senator Parker had initiated that bill last year.
And Senator Parker's here in the room. Okay. What we essentially did was recommend adoption of Senator Parker's language from that bill, and Senator Parker can correct me once I stray, but the language was included in the statute concerning emancipation, and what it allowed the Chancery Court to do was, in its discretion, if an adult disabled child was, incapable of self-support beyond the age of majority, either for physical or mental reasons, to allow the Chancery Court to take that into consideration and order child support or the payment of health expenses or health insurance and other expenses in the court's discretion. That was another issue I felt that many of the majority of the task force felt strongly about, and we liked the language that was included in the statute that required the court to take into consideration what effect that would have on that adult disabled child's entitlements or public support, so as not to to allow that adult disabled child to still maintain the highest standard of living he possibly or she possibly can. So that was the recommendation.
Can you say where Mississippi was ranked compared to other states?
I don't remember, Chairman.
My recollection is we were one of the few that did not allow that.
That would not be
either via statute or case law or some other type of way.
And I can affirmatively state that the state of case law in the state of Mississippi is there is absolutely zero obligation to pay for child support for any child once they reach the age of emancipation.
Which I think is the problem, which is why you have to have a statute, because the case law has said exactly that, which is why chancellors can't grant it at this stage.
Right,
if I may, no, go ahead.
I was about to pontificate on case law, so don't let me start. Go ahead.
I was going to say that if I'm going to digress here and let Senator Parker weigh in on that if he would like, because I know he pushed that.
Thank you, Mr. Chairman. Thank you, Judge, for your work on this. And this has been an issue that I've been looking into for I think probably about 6 years now. And the question on it has always kind of come up, what about unique circumstances that come up? So say this adult child became a ward of the state, after emancipation, and the other spouse was not taking care of him. And in the language I've seen so far in the bill that has been drafted, there have been a couple of extra qualifiers in there that I think got to some points that many, many years ago, when one of our other senators, Senator Hobson, was chairing this committee, he had some great concerns about, and I'm very pleased with what I've seen. I don't have the bill in front of me to go into that, but I think this task force not only recognized the problem in relationship to what we're not doing compared to other states, but also looked at some of the issues that has made it more difficult for us to bring this bill forward by your insight and your attention to it. And so I would love to see this move forward. I would love the courts to be able to look at each case on an individual basis like this change in statute would do. And just thank you for your work on this, and I think this can definitely make a difference for many families who have this unique circumstance.
Thank you, Senator. Anything else on that issue? As one of the task force members said, it sounds like a no-brainer. I think is what a direct quote that they used. But I know that there are some interesting policy issues raised in some Supreme Court decisions about it. The third recommendation was the suspension of child support due to incarceration, and this initially raised by the Department of Human Services representative on the task force, requesting an administrative suspension of child support payments from the payor for those that are incarcerated for 180 days, aka 6 months or more. That was also a recommendation made, and DHS made a compelling argument to the committee about the reality that you can't earn money when you're incarcerated, and also the reality that it's harder to start immersing yourself back into productive society when you emerge with what is for some people crippling debt. It's a tough issue because it is the child and their child support payments that ultimately get the shaft. It's a tough issue because it is the payor's actions that caused their incarceration. But the reality of it is, and this is for the senators to debate, that can't squeeze blood out of a turnip. And to help these individuals emerge back into society, to administratively suspend them, that would of course also save money, according to DHS, because the cases before DHS, which amounted to like 1.2% of the cases that they have, would drop from the caseload as a result. Now, the recommendation still allows for a court to continue child support while the person is incarcerated upon a showing that those individuals actually have the assets to be able to pay for their child support. And there are some individuals, as we all know, that do have the assets available to continue paying their child support even when they are incarcerated.
And I will add, for the benefit of the committee, that, and Chairwoman Cockerham and I guess, discussed this all has fallen under the criminal justice standpoint that we've been doing. And if you recall, part of that is that throughout not only Mississippi but other states, that you keep piling these costs upon people and it becomes this vicious cycle. And under this recommendation, nobody's saying that they should be forgiven. What they're saying is they're unable to pay. And I will note that it's come before this legislature, this body, is that on federal law under Medicaid, you can suspend child support. I'm sorry, if I'm not mistaken, they get to stay on Medicaid in other ways because they have no other way to do it. Point being is that not setting up this cycle that continues on. And then as the judge said, that if somebody does qualify, the judge can enter that order and do that. And DHS, this amounts to 1.2% of their caseload. So it takes a little bit off of their backs that they don't have to worry about, at least for a time being, and they can focus on other ones, so.
That's correct. And the state of the law is very strong, as you can imagine, in favor of children. Those child support payments vest every month that they accrue, and once they vest, they become a judgment. So this administrative suspension would at least allow that not to become a judgment during long-term incarceration. Senator? Oh, I'm sorry.
Yeah, Senator Boyd.
Thank you. I wanted to just make sure I'm understanding this correctly. We are talking about once a person becomes incarcerated, that amount of child support is totally wiped away. Like, it is not charged during the time of incarceration.
Yeah, that's the amount that accrues each month that they are incarcerated.
And so after the person is released, just I'm asking for clarity right now. So after the person is released, there's no responsibility then therefore to make the custodial parent whole for the missed child support or anything like that? I'm clarifying, just.
I want to, that's a great question, and that's why it's such a tough question to be able to answer, because it is the custodial parent that did not break the law, that is bearing the burden of raising that child. And as anybody in here who has children knows, that's not a cheap proposition. It's very expensive. But the realities are what the realities are, and they're not able to earn that money while in prison. And how are we going to get them back into society was the issue with DHS in addition to their caseload. Is it going to be the vicious cycle we talked about, or are we going to, and here's another thing, Senator Boyd. When there is crippling child support debt as a result of, let's say, incarceration where you're unable to earn the money, once they do get out, the relationship is more difficult to get back together with their natural parent because the custodial parent is upset about the non-payment of child support, and we're not going to have visitation until I get that child support paid, and it may damage the ability of that person who was incarcerated to get back with the parent. We see it all the time, parents holding their children hostage for non-payment of child support, and it's disturbing to see. But it's a tough question to answer, Senator. I understand both sides.
And I will note that the DHS did say they're spending a lot of time and effort on 1% of the cases that don't result in actually getting child support in the door because they can't do it. So that was part of it. Senator England, you had a question? Oh, okay.
And you can be assured, even though it's only 1.2% of their caseload, every single one of those cases are going to be brought back up for contempt or non-payment subsequently, even though it's such a small part of the caseload.
Yeah, Senator Branning.
Judge Odom, thank you for your work. Did you tell the committee how many other states handle the incarceration issue? I may have missed that point, but I'm interested to know how other states handle it.
I'll tell you, that was DHS's main point, and I remember Michael McCallie or the DHS representative talking about that, what the other states do. Yeah, the other states suspend it. I think there's even a federal regulation that requires that to be taken into consideration when modifying downwardly during an incarceration. So I can't answer intelligently. I don't know, but I know that that was raised during the committee discussions. It's not an anomaly.
Senator Hobson.
Thank you, Mr. Chairman. Judge, thank you. Good to see you.
Good to see you.
Am I correct in understanding, though, as for a person that would have an arrearage going into prison, that would not be removed? It would only be the child support that would be due to the non-custodial parent from the time that they're incarcerated.
That's right. And would still continue to accrue, I believe, 6 months into their incarceration.
That's the recommendation of the committee?
Yes.
Okay, and then let me just kind of ramble through this for a minute. Let me just get my thoughts together on how this would work. It looks as though in these recommendations that MDHS would have an administrative or have the administrative authority to stay or abate the payments while the person's incarcerated or from 6 months forward. What if this is not an MDHS? What if it's you and your wife or me and my wife, and we've got suddenly go to prison and there's nobody's collecting for you. This is a direct payment you made every month. How would the administrative process work to stop those payments once you're incarcerated?
Yeah, the way I read the literature provided by DHS was that it would be statutory, that it would be statutorily cut off for anybody that was incarcerated for longer than 180 days. So I say administratively cut off. Maybe automatically cut off would be a better use of the term. And it wouldn't just apply to DHS cases, it would apply to non-DHS cases as well, because they're not handling all of the child support collection in the state of Mississippi, just those that are receiving benefits.
Yeah, that makes sense. And then again, I'm going to assume here the presumption at that point would be, or maybe not the presumption's the right word, the onus would be on the non-custodial parent then to go back to court to say, well, Judge Odom or Senator Hobson, they've got plenty of assets to take care of that problem. They should not be abated or stayed in any way. Am I correct in that?
And we're collecting from Senator Hobson.
Yeah.
That is correct. The onus would then, the burden would then shift to the payee to raise it to the court. Hold on. This person owns extensive land in the Delta. This person has millions in his bank account or her bank account.
Yeah.
I mean, not everyone that goes to prison is poor.
Okay. And I would again imagine that under those circumstances, the court would have the authority. There would be nothing that preclude the court from awarding the attorney's fees for the payee in pursuing that to also be paid attorney's fees on their effort to come back into court to get the incarcerated parents' portion of child support.
Good question. You'd have to add that statutorily.
Okay.
We can't award attorney's fees unless there is an inability to pay, which of course that would present itself for that position. But if you're wanting to guarantee the attorney's fees for the person bringing the case, then you would want to put that in the statute so that we can.
Yeah, I would think it'd be appropriate to give the court the authority to determine whether or not have that ability to order the award of attorney's fees to the incarcerated parent in the event that they've got the assets to cover.
And the law is, as it stands now, is similar, except that the burden is really on the incarcerated person to raise it. If they raise it while they're incarcerated, absolutely, there's a material change in circumstances and their child support is going to be modified, maybe even to zero because of the inability to earn money while incarcerated. But prisoners don't have the resources to hire attorneys, even though they sometimes think they are excellent ones. It just doesn't get raised. It's just not something that's on their mind because how are you going to collect from me? Sort of thing, mentality. So it's really just to, I know it sounds odd, but in the end, the committee felt that the long-term effects would be more positive than negative here with the automatic suspension.
Thank you for your indulgence. Thank you, Mr. Chairman.
Senator McCon?
Thank you, Judge. I do have some questions, I guess piggybacking off the chairman there. So currently, it's on the incarcerated individual. The burden would be on them to petition the court for the material change in circumstance. If we do this, we're automatically stating that it would be now on the, let's just say, the custodial parent who has this child in their care while the non-custodial parent is in prison to find out that this individual is now out of jail. Administratively, you've suspended this. They're out of jail now. They're, in theory, supposed to be working. how are we going to get notice to these people? And how are we shifting the burden now to them if it's not a DHS case? For that mother or that parent then to go petition for the reinstatement of that, which we're now saying, hey, you got to pay $147, $35 for a service process fee, and $750 for Senator Barrett over there to go file the case.
Great question. I don't know that it's going to be any different from the state of the law today, because once that person is out of prison, and certainly the state of Mississippi knows when they're released from incarceration, the payments automatically start back up. The child support starts vesting once again. So just like in any other situation where somebody is incarcerated, it's always incumbent upon the payor or the payee, unfortunately, the custodial parent, to try to track them down in order to get payments. But at least here, under the statute, the child support payments would automatically start right back up. What is it, 30 days after release? So that it still accrues as a judgment against them, even if they're trying to evade the custodial parent.
What rate are we talking that it's going to start accruing back at? Minimum wage?
It would, I would imagine it would start back at what it was prior to the incarceration.
Okay. And as far as the notice of the individual now being out of prison, person on the coast, the person got the person in jail, the incarcerated individual now is in North Mississippi. I mean, I'm just asking questions about how the semantics, all this is going to work.
It's kind of
how you would get notice back.
It's shocking to me that there's not already an administrative policy that requires the Department of Corrections to inform a custodial parent that the payee is now released from prison and the child support payments are going to start back up. Sounds like a great bill to draft up.
Don't tell him, he'll send it to me.
That's a great point, but that's the problem that's in existence today, even without the passage of that bill. Anything to try to, I think it sounds like a good idea, personally.
I will add to this, and Judge Odom can correct me, but I think during the task force, what, for lack of a better term, carried the day was the relationships between parents and kids, be it in divorce situations. And this is not an easy issue, but like Judge Odom said, these things are used, I use the term weaponized. The reality is child support, divorce is used as a weapon. And correct me if I'm wrong, Judge Odom, and I think the task force with Chairwoman Cockerham and myself seeing it was looking at the relationships with the idea that we want relationships between wherever the parent may be and the children are better. And the court system, in essence, was contributing to the problems that we're seeing, honestly, in this state. It certainly is not making it easier. So on this, while it's difficult, and I would say to Senator McCon and anybody, in Judge Odom's defense, this did come from DHS, and I certainly hope they're listening, because I think these are valid questions that if they've requested this, and this is what we're going to get. But they also mentioned about the relationship. So that's something to think about. And do you have anything to add? Am I fairly?
I touched upon it earlier, and that we're all sinners. We're all sinners. We're never going to get away from weaponizing child support and visitation and the other things that we've talked about. But any little thing that we can do to try and alleviate those weapons or get rid of them would be helpful to the Chancery Court, trying our hardest to help the people of the state of Mississippi, the families.
Judge, we got 9 minutes, so you're welcome to conclude it up.
All right, I will conclude it up by saying that, like I said before, we begged Senator Wiggins, Representative Cockerham, to please reconstitute the legislative task force. I can assure you from the Judges Committee, or from the Judges From my fellow judges, they were pleased as punch to know that they had a voice here at the state legislature. They thought it was a great way in order to make that voice heard. There were a lot of charges in Senate Bill 2621 that we were not able to get to, including guardian ad litems, including the child support calculations. Justice Griffiths had yet another issue that he wanted the task force to bring up that we were unable to get to. We wanted a task force reconstituted. We want it to be enabling immediately, as soon as possible, so we'd have a little bit more than 3 months before we can have a final product to the legislators. And it was a pleasure and an honor to
And
serve
you're
y'all.
agreeing to be chairman if it's reconstituted?
I've got a plan. I'll take it. I mean, I've got a
Okay.
plan to do it and to address all of the important issues that y'all have so that we can make one recommendation or another, and then y'all can make the final decisions. Thank you for your time.
Okay, Senator McConnell.
Another question, I'm sorry.
Easy question. Last year, we tried to make this committee balanced as far as practitioners, as far as judges. Did you feel like it was a fairly balanced committee from your work there?
I would like to see more chancery judges on the committee.
I want to see you do your signature, Judge. That's what I really want to see.
I'd like to see more chancery judges on the committee, which would also give us the opportunity to get more diversity on the committee as well.
Thank you, Judge, for your leadership on this. Thank you to the task force. And I do, for the members of the committee, so that you know, Representative Cockerham and I, we're discussing which bills will come from which chamber. And so I guess you can be on the lookout for that if you have any questions. So thank y'all for doing this. Appreciate it. Have a motion? Rise and report. Thank you very much. We're adjourned.